This presentation is about the Supreme Court's recent landmark decision in Sevilleja and Marex, fundamentally restating the rule against the recovery of reflective loss, or the no reflective loss rule, as it's also sometimes known. I acted as junior counsel for the successful appellant in that case. This is a shortened version of a talk I delivered on 23rd of July. If you're interested in the longer version, please contact the clerks at 1 Essex Court. I'll start this presentation with a summary of the law prior to the Supreme Court's decision, so you can fully appreciate the significance and impact of the decision. I'll then briefly mention the factual and procedural background before looking at the Supreme Court's decision in more detail, finishing off with the commercial and practical implications of the judgment. Before the Supreme Court's recent decision, the rule against the recovery of reflective loss was, put simply, a rule that prevented unsecured creditors or shareholders, whether they were suing qua shareholder, employee, or creditor, from recovering for loss suffered primarily by the company as a consequence of the defendant's wrongdoing, notwithstanding the fact that this wrongdoing also gave rise to a separate cause of action for the creditor or shareholder. The term reflective loss was used to confer the idea that if loss suffered by the company was remedied, then the shareholder or creditor's loss would disappear. The rule against recovery of reflective loss originated in a case called Prudential Assurance and Newman Industries. The directors of the company were alleged to have made a fraudulent misrepresentation in the circular distributed to its shareholders, so as to induce them to approve the purchase of assets at an undervalue from another company in which the directors were interested. Prudential was a minority shareholder in the company and brought a personal and derivative action against the directors, claiming that they'd committed the tort of conspiracy against the company and its members. The Court of Appeal only briefly considered the personal action and concluded that where a company and its shareholders had suffered wrongs which resulted in a loss to the company and a fall in the value of its shares, a shareholder could bring a personal action against the wrongdoer because the shareholder the shareholder could not bring a personal action against the wrongdoer because the shareholder had not suffered any personal loss because such loss is merely a reflection of the loss suffered by the company. The only loss of the shareholder is through the company in the diminution in the value of its net assets. Prudential was considered by the House of Lords in a case called Johnson and Gore Wood, and the Prudential rule was thereby changed into a general rule against the recovery of reflective loss. That case concerned the alleged negligence on the part of the solicitors acting for a private company which caused it to suffer losses. The company brought proceedings against the solicitors, which were settled during trial. The claimant, Mr. Johnson, who owned virtually all the shares in the company and was its managing director, then brought proceedings against the solicitors in which he alleged that they'd also acted in breach of duty owed to him personally and that he had suffered personal losses. The claim was struck out as an abusive process. Mr. Johnson then appealed against the striking out of his claim, and the defendants cross-appealed to have certain heads of loss struck out on the ground that Mr. Johnson was seeking to recover for damage which had been suffered by the company. Lord Bingham extracted 3 principles concerning the rule against the recovery of reflective loss from the case law, which have since become the sort of seminal statement of the rule. The first point you can see on the slide is the general statement of the rule, and then there are 2 exceptions to it. It's important to understand what the House of Lords held on the facts of the Johnson and Gore Wood case, because that has been used subsequently, together with Lord Millet's speech, about which I'll say more in a moment, to expand the rule to claims brought by shareholders in their capacity as employees or creditors of the company. The law lords struck out 2 heads of claim brought by Mr. Johnson, namely, firstly, the fall in the value of his shareholding in the company, and second, a claim for loss in respect of the value of a pension policy set up by the company for his benefit. The House of Lords appeared to treat pension contributions as a form of distribution from the company's profits to its 99% shareholder. However, the House of Lords allowed claims for other losses, for instance, the cost of personal borrowing, additional tax liability, and the loss of a shareholding in company given as security for a loan, which could not be redeemed given Mr. Johnson's lack of funds following the wrongdoing. The other important speech in Johnson and Gore Wood was given by Lord Millet. This speech has proved particularly influential in subsequent cases and has now been heavily criticised by the Supreme Court. The starting point to Lord Millet's reasoning, which in particular Lord Sales called a false premise in the recent decision in Marex, was that the alleged relationship between the company's assets and the value of its shares. A share, said Lord Millet, represents a proportionate part of the company's net assets, and if these are depleted, the diminution in its assets will be reflected in the diminution in the value of the shares. According to Lord Millet, the problem which arises where there is a breach of duty to both the company and the shareholder, and both suffer loss, is the risk of double recovery and the risk to the company's other shareholders and creditors through the depletion of assets. And that's the reason why, according to Lord Millet, recovery by the shareholder cannot be permitted. To explain why a shareholder cannot sue when the company has settled its claims or is not pursuing its claims, Lord Millet used causation. What causes the loss in those circumstances is the company's decision, not the wrongdoing. Because the possibility of double recovery arises each time where concurrent claims exist, Lord Millet considered that the reflective loss principle extends beyond the diminution of the value of shares and the loss of dividends to all other payments which the shareholder might have obtained from the company if it had not been deprived of its funds, even if the claimant would have received them qua employee and not qua shareholder. So by using the avoidance of double recovery as the foundation of the rule against the recovery of reflective loss, Lord Millet paved the way for the expansion of the rule beyond the narrow ambit of prudential. The wide scope of the rule against recovery of reflective loss was confirmed in Gardner and Parker, which involved a claim by a shareholder who was also a creditor of the company. The Court of Appeal held that the no reflective loss principle applied to such a claim, and in particular the creditor's inability to recover a debt owed to it by the company in which he was a shareholder. They relied for their reasoning on the treatment of the claim for the loss of the pension policy in Johnson and Gore Wood, which I've mentioned, and applied Lord Millet's dictum that we've just looked at. But Lord Justice Neuberger, who gave the leading judgment in the Court of Appeal, went much further and said, although this was obiter, that the same reasoning should apply where the employee or creditor was not a shareholder of the company. And this is the case that was used by the Court of Appeal in Marex and Sevilleja to expand the rules to unsecured creditors who are not shareholders in the relevant company. Now, with the scope of the no reflective loss rule ever expanding, the question obviously arose whether there were any limits or exceptions. Given the potential unfairness to shareholders in cases where the company does not bring proceedings against the wrongdoer, it's hardly surprising that an exception was recognized in Giles and Ryan. In that case, the company's action for damages had been discontinued due to its inability to provide security for costs as a result of the impecuniosity caused by the defendant's wrongdoing. The terms on which the action was discontinued precluded the company from bringing any further proceedings in relation to its claim. The claimant thought to recover for a variety of losses, including the loss of value of his shares. And the Court of Appeal in that case allowed the claim to proceed and said that where by reason of the wrong done to it, the company is unable to pursue its claim against the wrongdoer, then the shareholder is entitled to pursue the claim against the wrongdoer. It would be unjust to allow a wrongdoer to rely on his own wrongful conduct to defeat a shareholder's claim. But that Giles and Ryan exception proved to be a narrow one. It was heavily criticised, including by Lord Millet when he was sitting as judge in Hong Kong, and was rarely applied even in this jurisdiction. Similarly, a number of cases held that whilst the no reflective loss principle bars recovery of damages, a shareholder is entitled to other remedies, and the English law rule in any event doesn't apply to foreign causes of action. So that is where the law stood prior to the Supreme Court's decision in Marex. The scope of the rule appeared to be ever expanding, although its legal basis and limits remained somewhat unclear, and the exception in Giles and Ryan was controversial. So the rule was clearly ripe for consideration by the Supreme Court. I should say a few words about the facts of the Marex case, which are relatively straightforward. Marex accuses Mr. Sevilleja of asset stripping two companies ultimately owned and controlled by him, so that they were unable to pay their judgment debt to Marex, pursuant to a judgment that Marex had obtained in 2013. From documents obtained pursuant to disclosure orders after that judgment, Marex discovered that immediately after circulation of the draft judgment against the companies and continuing after hand down of that judgment, Mr. Sevilleja deliberately procured to transfer funds in excess of some $9.5 million from the company's bank and brokerage accounts in London to overseas accounts in Dubai and Gibraltar, and Marex says ultimately into his own control. The companies are now in liquidation in the BVI, and apart from some recoveries made in the US, Marex has not been able to recover its judgment debt against the companies. Marex therefore sued Mr. Sevilleja on the basis of unlawful means conspiracy and for knowingly inducing and procuring the companies to act in wrongful violation of Marex's legal rights under a judgment. It sought to recover the judgment debt as well as costs of enforcement of that judgment. Now, Mr. Sevilleja challenged the English court's jurisdiction, contending, amongst other things, that the rule against the recovery of reflective loss barred Marex from showing a completed cause of action in tort, of which loss is an essential element. Mr. Justice Knowles at first instance, however, dismissed that jurisdiction challenge. He held that Marex had the better of the argument that the rule against the reflective loss recovery did not apply to the causes of action on which Marex relied, the primary focus of such actions being on the loss to the claimant rather than the company. And given his conclusions, it wasn't necessary to consider the Giles and Rind exceptions. But Lady Justice Asplin gave Mr. Sevilleja permission to appeal to the Court of Appeal on reflective loss only. And the Court of Appeal unanimously allowed Mr. Sevilleja's appeal, holding that Marex's claims as an unsecured creditor were barred by the no reflective loss principle, except in relation to 10% of the losses which concerned costs of enforcement of the judgment, which were separate and distinct from losses suffered by the company, and therefore Marex could pursue its claims. First, Lord Justice Flo, who gave the leading judgment, held that Mr. Justice Knowles's analysis, focusing on the nature of the causes of action rather than the loss suffered by Marex, could not be reconciled with the ratio, for instance, of Gardner and Parker. Second, he decided that the rule against reflective loss also applied to claims by unsecured creditors who were not shareholders of the relevant company, having noted that as a matter of authority following Johnson and Gore Wood, the rule against reflective loss precludes claims by shareholders qua employee or creditor. Lord Justice Flo said the rule should also apply to all creditors of the company to do away with what he called an illogical, unprincipled, and artificial distinction between shareholder creditors and non-shareholder creditors. Finally, Lord Justice Flo said that the exception in Giles and Rind was a narrow one and did not assist Marex in this case. Now, the Court of Appeal's decision had a wide-ranging impact. It meant that lots of claims by shareholders and unsecured creditors were effectively barred, and lots of claims were stayed in the commercial court pending the appeal to the Supreme Court. And the exception in Giles and Rind was really emasculated, leaving it with almost no practical application. The Court of Appeal, however, gave Marex permission to appeal to the Supreme Court, and there were two issues for the Supreme Court, which I've set out on the slide. Marex expressly invited the Supreme Court to overrule Johnson and Gore Wood. Now, Marex essentially presented an opportunity for the Supreme Court to review and reconsider the entirety of the no reflective loss rule, including the cases of Prudential and Johnson and Gore Wood. And the Supreme Court itself clearly considered that the case was an important one. Marex's appeal was heard by 7 justices of the Supreme Court, and the all-parliamentary group on fair business banking was given permission to intervene in support of Marex's appeal. Now, during hand-down on the 15th of July, Lord Reed acknowledged that the Marex appeal had raised one of the most important and difficult questions of law to come before the Supreme Court for some time. So what did the Supreme Court decide in its important decision? Now, in its 82-page judgment, the Supreme Court unanimously 7-0 allowed Marex's appeal and held that the no reflective loss rule does not bar claims made by unsecured creditors. All 7 justices agreed that Prudential did not establish a principle of the law of damages against the recovery of reflective loss, that Lord Millet's judgment in Johnson and Gore Wood in relation to the no reflective loss principle should not be followed, and that a number of Court of Appeal decisions had to be overruled. But the court was divided as to the basis on which the appeal should be allowed, and a major part of the speeches is taken up by considering the scope and application of the rule in respect of claims by shareholders. The majority, led by Lord Reid, with whom Lord Hodge, Lady Black and Lord Lloyd-Jones agreed, decided to retain the so-called no reflective loss rule as a bright-line legal rule of company law, although confined to the narrow ambit established in Prudential. It bars claims by shareholders for the diminution in value of their shares in a company or for the loss of distributions which the company would have paid to them in circumstances where wrong has been done both to the company and to the shareholder, even if the company does not pursue its own course of action. The minority, led by Lord Sales, with whom Lady Hale and Lord Kitchen agreed, took a more radical approach and in effect abolished the rule entirely. There can be no doubt that the Supreme Court's decision is significant. It restated the law in respect of reflective loss, overturning a House of Lords decision that had stood for nearly 20 years and other Court of Appeal decisions which had significantly expanded the rule. The Supreme Court decision brings a large degree of clarity and simplicity to this area of the law, which previously produced some perplexing results. Let's look at the 3 judgments and the reasoning in a bit more detail. Starting with the majority's judgment given by Lord Reid, he formulated his conclusions as follows. The rule in Prudential, he said, is limited to claims by shareholders that as a result of action and loss suffered by their company, the value of their shares or the distributions they receive as shareholders has been diminished. Other claims, whether by shareholders or anyone else, should be dealt with in the ordinary way. So in other words, as Lord Reid explained, one really must distinguish 2 cases here. The first one are those in which claims are brought by shareholders in respect of losses suffered qua shareholder in the form of a diminution of the value of their shareholdings as a consequence of losses suffered by the company, which itself has a cause of action against the wrongdoer. In those cases, the shareholder is precluded from making a claim by the rule against the recovery of reflective loss. The second type of case are those where a claim is brought by a shareholder or anyone else for losses not within the first category, but where the company has a right of action for substantially the same loss. In those cases, recovery is permitted in principle. So let's unpack that reasoning in a bit more detail. Lord Reid derives the rule in Prudential from what he calls the proper interpretation of the judgment. And he says that case established a bright line rule of company law and not a wider principle of the law of damages against double recovery. A shareholder cannot sue in respect of a diminution in the value of its shareholding or a reduction in the distributions which he would receive by virtue of that shareholding in consequence of a wrong done by the defendant to the shareholder, because such loss is in the eyes of the law not loss which is separate and distinct from damage suffered by the company, and it's therefore not recoverable. In effect, the law deems the shareholder's loss not to exist, or the shareholder not to have suffered any loss. And where there's no recoverable loss, it follows that the shareholder cannot bring a claim, whether or not the company pursues its own course of action. Now, that rule applies even in cases which Lord Reid acknowledged existed, where there is no direct correlation between the company's loss and the shareholder's loss, in that replenishing the company's assets by way of an award of damages would not necessarily fully compensate the shareholder. Lord Reid considered that in Johnson and Gore Wood, the House of Lords purported to follow Prudential, but noted that some law lords, in particular Lord Millet, went further than the confined circumstances of Prudential and criticised his speech. It's therefore only natural for Lord Reid to have said that Johnson and Gore Wood should not be followed in respect of the reflective loss principle, apart from Lord Bingham's speech, and that Gardiner and Parker had to be overruled. Lord Reid also closely analysed the rationale for the rule. For him, The avoidance of double recovery is not sufficient in itself to justify the prudential rule. It does not explain why the rule applies where the company does not pursue its own course of action, or where there's no close correlation between the company's loss and any fall in the share value, because in those cases, there's obviously no risk of double recovery. In any event, he said, the principle against double recovery does not prevent a claimant from bringing proceedings, and there are other mechanisms to avoid double recovery or double proof in insolvency where there are concurrent claims, including procedural means and subrogation. The critical rationale for the rule, said Lord Reid, is the unique position in which a shareholder stands in relation to the company, reflected in the company law principle known as the Foss and Harbottle rule. Put shortly, Foss and Harbottle states that the only person who can seek relief for an injury done to a company where the company has a cause of action is the company itself. That rule would be subverted if the shareholder could pursue a personal action in circumstances where the company has suffered loss as a result of wrongdoing and has its own cause of action. Indeed, given his unique position, the shareholder doesn't need an independent cause of action, says Lord Reid. The shareholder has other remedies available to him. He exercises ultimate control over the company's decision-making by voting in a general meeting, and so can make the company pursue its cause of action. And a shareholder, unlike a creditor or employee, has the right to bring a derivative claim to enforce the company's rights if the relevant conditions are met, and the right to seek relief in respect of unfairly prejudicial conduct or the winding up on just and equitable grounds. And Lord Reid said there are pragmatic advantages to having a clear rule that only the company can sue for cases falling within the ambit of prudential. That avoids having to deal with double recovery, case management issues, and therefore doesn't leave the protection of creditors and shareholders to the complexities of a trial. Now, as prudential establishes a bright line rule of company law, there can be no exceptions, and there's no flexibility or discretion involved. The way to prevent injustice in appropriate cases is for the shareholder to exercise other remedies, for instance, an unfair prejudice petition or a derivative claim, if he is not in control of decision-making of the company by voting in a general meeting. It therefore followed that Giles and Rind and Perry and Day, where the Giles and Rind exception was applied, had to be overruled. Now, Lord Hodge agreed with Lord Reid, but he gave a separate judgment because the division of the views to whether a shareholder can recover damages for the diminution in value of its shareholding or loss of distribution. And he said it was important to add a few comments on the central role of company law for the prudential rule. According to Lord Hodge, the prudential rule is a rule of company law arising from the nature of the shareholder's investment and participation in a limited company, and exclude the shareholder's claims made in its capacity as shareholder. Lord Hodge considered that the rule was a principal development of company law and gave 5 reasons for this. First, it excludes the possibility of double recovery. Second, it avoids a scramble between shareholders to establish their private claims against a wrongdoer in cases where the wrongdoer may not have sufficient assets to meet all claims. Third, it upholds the default position of equality amongst shareholders. Each shareholder's investment follows the fortunes of the company. Fourth, it maintains the rights of the majority of the shareholders. And finally, it preserves the interests of the company's creditors by maintaining the priority of their claims over those of shareholders in the event of a winding up. Now, Lord Hodge said, the rule stood for 39 years, has been followed in other jurisdictions, and so it should not be departed from. Turning then to the minority, Lord Sales giving the judgment with whom Lady Hale and Lord Kitchen agreed, they took, as I've said, a much more radical approach. In short, they said, Prudential was correct on its facts, but did not establish the bright line rule of company law contended for by the majority. Double recovery is important in relation to both shareholder and creditor claims, but since double recovery can be avoided by other means, Lord Sales questioned whether the no reflective loss rule should be recognised at all. And even if it should be maintained, he was very clear it did not apply to claims by creditors of a company who are in an entirely different position. Now, what lies at the heart of Lord Sales's judgment is the rejection of the idea or legal fiction that loss suffered by a shareholder is the same as the loss suffered by the company. According to Lord Sales, the loss suffered by the shareholder may in fact be greater or less than the loss suffered by the company. This is because a share is a piece of property whose market value depends on the estimation of the future business prospects of the company and not just its net asset position. The precise loss actually suffered depends on the facts of each case, but broadly speaking, the shareholder's loss is typically the diminution in value of the shares, taking into account the impact on the value of those shares of the company's right of action against the wrongdoer. Now, because the loss of the shareholder is not the same as the loss of the company, it doesn't follow that eventual recovery by the company will have the effect of eliminating or wiping out the loss suffered by the shareholder. And since the shareholder has suffered loss and has a cause of action, he should be entitled to sue in order to vindicate his rights if he can indeed prove that loss. There's no policy reason, said Lord Sales, to exclude or eliminate the shareholder's personal claim, and disallowing a personal claim would in fact erode the separate legal personality of the company. And even if a shareholder reduces the assets of the wrongdoer available to compensate the company, that is no reason to disallow the claim. The shareholder owes no duty to the company or its creditors, which prevents him from seeking to enforce his own rights. Lord Sales therefore considered that the Court of Appeal's reasoning in Prudential as to why a shareholder in fact suffered no loss, or had to be deemed to have suffered no loss, whatever the true position on the facts, could not be supported. According to him, there are clearly cases where a shareholder does suffer a loss which is factually different from the loss suffered by the company. He said that the Court of Appeal in Prudential merely recognized, and rightly in his view, that on the facts of the case, the shareholder had in fact suffered no loss. Prudential had not adduced evidence and pleaded no particulars that the market value of its shares had been detrimentally affected by the fraud. There was no expert evidence on the impact of the overpayment for the asset on the value of Prudential's shares. Rather, Prudential merely relied on the company's loss for its own course of action. Lord Sales therefore concluded that Prudential did not lay down the rule contended for by the majority, whilst he recognized that certain advantages in a bright line rule, for instance, the elimination of the need to debate the interaction of the company's cause of action and the shareholder's cause of action, this simplicity, he said, is produced at the cost of working serious injustice for the shareholder. He therefore advocated that the position be fully explored on a case-by-case basis in light of all the facts with the benefit of expert evidence in relation to the value of shares and due sensitivity to the procedural options which are available. Now, unsurprisingly, given his views on Prudential itself, Lord Sales was also critical of the House of Lords judgment in Johnson and Gorwood, in particular Lord Millet's speech, and held that it cannot be regarded as authority for the special rule of law identified by Lord Reed and Lord Hodge. Lord Sales also considered whether there were any policy reasons to support the rule against the recovery of reflective loss, but he rejected those previously advanced in support of the rule and cited by Lord Justice Flo in the Court of Appeal, namely double recovery, causation, avoiding conflict of interest, and preserving company autonomy and avoiding prejudice to minority shareholders and other creditors. Whilst Lord Sales considered double recovery to be important to shareholder and creditor claims, it was insufficient to warrant the rule, he said. Because losses are not identical, double recovery doesn't necessarily follow in each case, and in any event, double recovery can be met in other ways than by the no reflective loss rule. In particular, he said, there are procedural means, and in particular, case management powers that can deal with the coincidence of claims. For instance, a shareholder might have to give notice of his claim to the company so that the court consider the interaction between the claims in a pragmatic way with full information as the proceedings progress. Or a claim which the company may wish to bring has to be heard first so that the shareholder's loss can thereafter be calculated, taking into account the recovery made by the company or giving credit for any increase in the market value of the shares. That, said Lord Sales, is an aspect of working out the application of the principle of compensation in light of what is known at the time of the judicial decision, see the Golden Strait decision. Another option is, for instance, to get an undertaking from the company or liquidator that it won't sue, so the issue of double recovery doesn't arise at all. Now, Lord Sales was also firm in his view that the rule against the recovery of reflective loss did not apply to creditors, even if such rule existed for shareholders, which he seriously doubted. Creditors are in an entirely different position, he said. They have not signed up to follow the fortunes of the company in the same way as a shareholder has, and in any event, prudential, he said, is a flimsy foundation on which to build outwards into other areas of the law. And the fourfold policy considerations, which I've just mentioned, did not justify the application of the rule to creditors. In an article relied on by the Supreme Court, the reflective loss principle was likened by a leading academic to some ghastly legal Japanese knotweed, whose tentacles have spread alarmingly wide and which threatens to distort large areas of the law. As Lord Reed said when handing down the court's unanimous judgment that the no reflective loss rule does not apply to unsecured creditors, the Japanese knotweed has, we hope, been eradicated once and for all. Indeed, the Supreme Court's decision significantly narrows the scope of the no reflective loss rule and thereby brings much needed clarity and simplicity to the law, as well as legal certainty. The principle is now limited to claims by shareholders for diminution in value of their shares or other distributions from such shareholdings, where there are concurrent claims by shareholders in the company. But where the company has no cause of action, the rule does not apply. There are no exceptions to the rule, and there is no doubt that the rule does not prevent claims by shareholders, qua employees or creditors, or indeed unsecured creditors. The practical effect is that many more claims are now permitted by law and will not be struck out. It provides claimants, and in particular creditors, including those of companies in liquidation, with alternative avenues to recover debts. In practice, there's little room for argument around the scope of the no reflective loss rule or its application. Rather than having to engage in case management to address double recovery, the bright line rule simply avoids this issue. In that sense, the decision is a clear win for simplicity and clarity. Life for practitioners and clients should be easier. But that's not to say that the Supreme Court's decision is the last word on the issue. And in my view, it's unlikely to be, and the no reflective loss rule may well be abolished. Lord Sales's speech is eloquent and powerful, and Lord Kitchen agreed with Lord Sales. They are amongst the more junior members of the Supreme Court, and it is not known what other members think on the topic who weren't part of the panel in Marex and Sevilleja. So whilst the court is unlikely to look at the issue again immediately, I will not exclude the possibility that the rule against the recovery of reflective loss is abolished before Lord Sales and Lord Kitchen retire from the Supreme Court. Indeed, if there were further case, depending on the composition of the court, the rule may well be abolished. What might be the right case to test that rule and that reasoning? Whilst Lord Sales didn't give a precise example, the case would obviously have to fit the fact pattern described in his judgment. There would have to be concurrent claims by the shareholder and the company, possibly an economic tort with an intention to harm the shareholder, which is not an element that would form part of the company's cause of action. It would definitely have to be a case where the shareholder has suffered greater loss than that suffered by the company, and even better, if the company pursues its own claim, which is then either resolved in parallel or before the shareholder's claim, so that the practical implications can be worked out, and it can be confirmed that the shareholder's loss is not eliminated or wiped out by compensation awarded to the company. In that case, one would have to grapple with the concurrent claims, concerns about double recovery, but could also deal with the question of principle, whether such a claim should simply be excluded in its entirety. That issue could be resolved by the Supreme Court in a leapfrog appeal by reference to a case where the issue arose fairly and squarely on the facts.